Hello and welcome to Magna Carta Prelims 2024. We are now on lecture number 3, which is legal history. Now, before we begin this lecture, legal history, as far as the prelims is concerned, tends to be covered under two subjects. One, of course, is polity, and the second is modern history. So we have to first be very careful in terms of how legal history questions are asked in the context of modern history, and two, how legal history questions are asked in the context of Indian polity. The basic difference is when modern history asks you questions on legal history, they generally ask the same from a non-institutional point of view. But when Indian polity sections ask you questions on legal history, they are often from what is called an institutional point of view, a structural point of view, an organizational point of view. The second important thing to remember is the prelims questions on legal history have been scarce. We've had about 2-3 questions in the last 10 years, and they have been fairly direct questions. And if not direct questions, they have been very logically deductive questions, which means that we have to prepare this very distinctively with a lot of restraint when it comes to the prelims exam. Also, if you bear in mind the syllabus for polity and governance, unlike the main syllabus where they categorically mention historical underpinnings, all that they mention with respect to the polity prelim syllabus is the constitution, which means just a little bit of context to the legal history is more than enough. And what I'm going to do in this particular lecture is not just cover the primary facts, but also make you understand the systems and the structures that have essentially evolved. So when we study the advent of colonial rule, we study it from an administrative point of view, from a structural point of view, from the development of state systems point of view. So let's begin. First things first, I'd like you to understand a few things. The first is you must understand the broad sort of milestones in our journey. Our journey effectively starts in the year 1600. And what happens in 1600 is the entry of the East India Company, the English East India Company. Now, this is generally done through a charter. A charter is directly sanctioned by the Crown of England, by the monarch of England. Now, when the company comes to India, it has been authorized by England to effectively run its operations and govern its subjects in India. Now, the company not only sees trade, but also finds ample opportunity to fraudulently and illegitimately diverse into the administration and the governance and taking over the control of affairs of the units which were a part of India at that time. But our first milestone happens to be when the Crown has authorized the company to enter India. Now, what slowly tends to happen is the company diversifies, enhances its reach, expands, and starts doing more things, which is not just about a trading company. It effectively also tends to become a pseudo or a semi-governing authority, which is why in 1757, through the Battle of Plassey, what you generally understand is that the company has formally acquired certain revenue collection rights. And revenue collection rights are a very important instrument of a governing authority. So basically what is happening is the company as a trading unit is now becoming a trading and a governing authority. And that is effectively cemented in 1757 through the Battle of Plassey. Post that, because power corrupts and absolute power corrupts absolutely, the company tends to become a little too mighty. While one can say that the revolt of 1857 was a triggering factor, but it was not the primary factor for this. But what happens in November 1858 is that the company becomes strongly more subject to the crown, to the British government, to the British ecosystem. So up until 1858, the company was functioning with a very high degree of autonomy. That autonomy was, of course, granted to the company through certain charters, through certain provisions. But that autonomy is going to be restricted. The British government is going to export their governmental structure and bring some order into the chaos that the company is tending to cause. And thereafter, what you see is an evolution of the British governmental administrative system in India. And also, simultaneously, we want to become independent. So these two forces are going to collide with each other, and eventually, on 15th August 1947, India will become an independent dominion. Yes, you heard that right. India becomes an independent dominion on 15th of August 1947. This means India was functionally independent, was free to do whatever it had to, but it had to still formally recognize England as its head of state. It had to formally recognize the Queen as its ultimate authority, even if it is ceremoniously, even if it is figuratively. But till on 15th August 1947, what we effectively become is an independent dominion of England. And once our constitution is up and running, has fully commenced, and every provision of the constitution is fully applicable to the territory of India, we become what is called a sovereign republic, which means we are again fully independent. And the difference this time is that we are a republic, which means our head of state, even ceremoniously, is not going to be the British monarch. It is going to be someone who we are going to elect, which is called the president. Now, these are your broad 5 milestones in the structural journey of India. These milestones will see a lot of events happening. You will see several factors influencing it. India would have witnessed the partition. India would have witnessed nationalist movements. India would have witnessed different forms of nationalist movements. And they're, of course, going to have an impact. But there's also another very important layer. While India is evolving, and that's because of how the British are making India evolve, the British are also evolving themselves. The British are turning from a full monarchy to a parliamentary monarchy as time passes by. So, as and when this happens more and more, the Parliament of England tends to become even more the more democratically representative institution. The ministers of England tend to have a larger role. So, the evolution of Britain from parliament, from a full monarchy to a parliamentary monarchy is obviously going to have an impact on the way the structures in India are also going to eventually pan out. So this entire ecosystem, as you'd like to call, effectively has 4 primary ingredients. So till about 1858, there are going to be laws which are going to give structure, power, autonomy, some functions to the company. I'd like to call them company laws. They're generally charters. Then post 1858, you will see proper British parliamentary acts governing a complete system of administration. In India, you'll generally see them to be called as the Indian Councils Act, the Government of India Acts, and so on and so forth. These are the two primary legal documents which had legal enforceability in India, illegitimately so, which have shaped India. So for the prelims exam, these two documents bear significant importance. Having said that, between the two, it is actually the crown laws part of it which is more important for polity, and the company laws part of it, the regulating acts and so on and so forth, would therefore be slightly more important for modern history. Apart from this, you would also see several documents which are written as a cause of our freedom movement. You will see them right from 1895, something called the Swaraj Bill, to a publication called the Revolutionary by the Hindustan Socialist Republican Association, to several documents written by Sapru, by B.N. Rao, and so on and so forth. Now, these aspirational documents, of course, would have some hint to the kind of India they want to build, but they would have more significance on the kind of rights, the kind of privileges, the kind of benefits, the kind of society that India should create. So therefore, they would generally be discussed, adopted and integrated through the Constituent Assembly, because at least in the more recent times, the authors of these aspirational documents would effectively end up also becoming members of the Constituent Assembly. And lastly, we'd also see some international inspirations. Now, these inspirations could be in two ways. For instance, the idea of something taken from a country and a specific provision taken from somewhere else. So, for example, the idea of fundamental rights has been taken from the US Constitution, whereas more specifically, the phrase procedure established by law has been taken by the Japanese Constitution. And if you've watched the second lecture, we've had a detailed discussion on the differences between the two and how they're very important constitutional theories, if I may say so. Now, having said that, again, these inspirations that have come to us internationally have never been asked in the prelims exam, at least in the last 10 years. When you do specific sections, for example, when I do directive principles, I'll give you a quick comparative inspiration that, oh, we've taken it from the Irish Constitution, and the Irish Constitution has in fact taken it from, let's say, the Spanish Constitution. But that is for another time. What we are to be absolutely focused on, and with the highest amount of priority, are in fact what are called crown laws. And what is it that we are eventually coming to? We are eventually coming to creating what is called the Constitution of India Act, and that is going to be done by the Constituent Assembly, who's been mandated to draft and to pass a constitution for India. The Constitution of India, as you would know, we've discussed this in the second lecture, has certain functions. In fact, I've given you two sets of purposes to the Constitution of India, to any constitution, in fact. One of them is, of course, the general powers and responsibilities, and I've given you the NCRT version of it. But generally speaking, the Constitution of India 1950 would effectively be looking at the structure of the state, the powers and limitations of the state, and the rights and responsibilities of the state, the citizens, and the interaction between the two. So this is the larger context that I think we should generally begin our lecture on. And now we should take a magnifying glass and get a little more deeper into this evolution, which is essentially a bunch of milestones. So, to begin with, who are the primary people involved? Because we are effectively a colony till about 1947, there are four sets of entities which are going to shape our governance and administrative structures. At the helm of affairs is going to be the crown or the monarch. Now, over a period of time, the crown or the monarch is going to lose their individual power, they're going to be bound by the Council of Ministers, as it happened as an outcome of the glorious revolution in England in 1688, if I'm not wrong. But the Crown plays a significant role because it is the Crown who issues a charter to the English East India Company to effectively come to India as the sole English trading company to go expand into foreign territories of India as viewed by the British. Over a period of time, you will see the British Parliament becoming stronger and stronger. So they will eventually end up making certain laws for us. For example, the Indian Independence Act, the very act that gives us independence, transfers powers from the British Crown to the Constituent Assembly. That legal transfer of power, because power, like matter, cannot be created or destroyed, it can only be transferred. It is effectively a British parliamentary law, and that in fact is also a point of critique, but not particularly important for the prelims exam. Thirdly, because there is a parliament and they also follow a parliamentary system, more specifically a Westminster system, called Westminster because the place where the parliament is, the area is called Westminster, the building is called Westminster, which is also why the system is called the Westminster system. Now, the basic essence of it is that if you are a parliamentary democracy, then there is going to be an elected house, and then there are going to be ministers from that house, and the ministers are going to be collectively responsible to the house. That's the general understanding of parliamentary democracy. So it is effectively the ministers who would have executive power, and the ministers would of course would want certain policies to be made, because for them a colony like India is also a source of revenue generation, as they would view it in their minds. And lastly, you would of course have the grand old company, which is headquartered in London. So the directors of the company are going to play a role in manifesting the kind of powers that the company would effectively have. Now, these four stakeholders, as we understand it to be, are not necessarily exclusive. In fact, there are going to be certain cooperations, and there are also going to be certain conflicts as and when the case might be. So, for instance, you would often see that allegations were made that the company was a little too close to the crown, and the ministers are going to have a little bit of a tiff or a little bit of a disagreement with the crown because of the kind of powers the crown was giving to the company, and the parliament would have a larger idea about what should be the future of India. In fact, this is one of the reasons why even after Lord Irwin's declaration that India would be given a dominion status, and India never became a dominion of England. What India became was an independent dominion in 1947. India never became a dependent dominion, though we wanted to become a dominion because Lord Irwin had also agreed to this. But what had effectively happened was that even after Lord Irwin's declaration, there was severe resentment and disappointment amongst the Britishers, which was reflected in the British Parliament, which is why Lord Irwin had to take back his words, and which caused us extreme disappointment, which led us to effectively shun all moderate negotiations with the British and completely be focused on the idea of Poon Swaraj, which was done through the Poon Swaraj Declaration, adopted in 1929 but made public in 1930. That, of course, your modern history teachers would effectively have taken care of, or your modern history books would address to it. But the stakeholders would effectively have some role to play in what is called the evolution of India. Now, we're going to look at two kinds of evolutions. On the first page, the kind of evolution that we're looking at is the political evolution, which simply means that as a political unit, as a unit of state, how has India evolved? So when the company came to India, we were basically a bunch of princely states. Now the company starts expanding, started claiming itself to be the ruler of these states, or to be the ruler of some of these. The company defeats a few. For example, that's what happened in 1757 when the company defeated Nawab Siraj-ud-Daulah and therefore gained Diwani rights. I'll discuss this. So then what happens is some of these areas are now under company rule, and you have some princely states. So collectively they become what are called British administered territories and princely states. And this continues to be the case till about we become independent. And just around that time, we are not just India, we are effectively undivided India. So it included India and current Bangladesh and Pakistan. Bangladesh back in the day was also called East Pakistan, and they were liberated in 1971. Now, we become undivided India with princely states. This is around the same time that the partition happens, and then we become what is called divided India, or we become independent India. The princely states become a part of India, and therefore what we have is called Union of India. So the British administered territories effectively become what is called independent India, and princely states are merged and consolidated and integrated, and what we effectively have is what is called Union of India. So this is what is called the political evolution of what is India today. And now we must look at the governance or the administrative evolution of what is India today. And that's the interesting part. So when we look at institutional evolution, we understand that there are three branches of state: the legislature and the executive, and of course the judiciary. Now, changes that happen to the legislature would effectively be reflected in the executive, and changes that happen to the executive would effectively be reflected in the legislature. So therefore, the changes that happened to the legislature and the executive must be done simultaneously, while the changes that happen to the judiciary could be looked at as a separate development. But the idea is that you've come to India as a company, and now you're growing your presence in India. Now, when you're growing your presence as a trading entity to a full-fledged governing authority, you'll have to put some systems in place. So what we have today in India as center and state and head of state and head of state at the center, and then you have you have the governor, you have the president, you have the prime minister, the council of ministers, the chief minister, the council of ministers. All that is effectively an evolution of what this is. All that is a byproduct of whatever it is. So if we talk about the modern day India, where you've got the president, you've got the Lok Sabha, Rajya Sabha, you've got the Council of Ministers, which is headed by the Prime Minister, you've got the Supreme Court. This is essentially the India of today. You'll have something similar at the level of the states, where you've got the governor and you have state legislative assemblies and so on and so forth. All of this goes back to this. So the general understanding is, what is it that these Britishers are going to do to us? Who are the people who are going to do what they're going to do to us? So in the prelims exam, you will generally see questions on the basis of this. You'll see questions on institutional changes, institutional landmarks, as opposed to political landmarks, as opposed to controversial landmarks, and so on and so forth. So you generally see that they'll set up something at a central level, then they'll set up something at the state level, because first they will only have one unit, and then they'll have sub-units. So that evolution is effectively what I've tried to sort of show to you here. Now, for example, you'll first start with a governor, then you will have governor general, and because this is a single person, the single person would be assisted by an executive council. Now, of course, you will see that the governor or the governor general will tend to not listen to the executive council. So they will want to control the powers of the governor by making sure the person listens to the executive council. But the governor would still have, or the governor general would still have, the last say or the final say. So what will happen is, at the union level, this will remain something constant for some time. And then you'll create an additional level. you'll create a sub-unit, you'll create a sub-national level, in a manner of speaking, of course. So you'll have a governor and an executive council. So when your territory becomes too big, you divide it into sub-units so that it's easier to manage. It is more accountable, it's more efficient. It is again still what is called a very handheld British-centric setup. So you'll have a governor general and an executive council, and at the states level also, at the regional level also, you'll have a governor and an executive council. Now, you still are making all the powers. The executive has the legislative powers. There are no functional differences because you are a colony. And if you want to sustain the colony, you'll have to have some amount of separation between your lawmakers and people who are implementing the law. What you'll do is you'll then create a legislative council. Now you'll have a governor general, an executive council, and a legislative council. You'll do this for some time, and then you'll replicate a similar system when your regional units have become huge, when there is enough resentment from us that we want representation. So when we want to be important, when we want our voices to be heard, what they would effectively do is they'll start giving us voices here because they still want to control the larger colony of India. So this is the larger unit, these are your subunits. So what effectively happens is you have an executive council, and then you will have a provincial legislative council after some time. You'll first have just governor and executive council, then you'll have governor, executive council, and a parallel fully functional system, a provincial legislative assembly and ministers. So this means there are going to be two centers of power. Of course, these guys are going to have more power because they're colonizers, but we will also have some powers that are ours, that we decide. Of course, because we are still a colony, the governor would have the final say, the governor general would have the final say. But the concept of having two sources of power, two parallel governments, two parallel law-making institutions, two parallel political administrative units, it is called diarchy, which of course we will study in a lot of detail when we look at one of the provisions that made us do this. Now, you would want to then take it a step more. You would still want to keep your integrity as of the colony of India intact. And then you will realize, if I want to keep Indians happy, I'll have to get rid of British influence at the regional level. So what you'll try to do is create what we have today here. So we will not be nationally independent and nationally democratic, but regionally we will have all powers to us. So we'll have a legislative assembly and we'll have ministers. Of course, the governor would be far more powerful, will have the final say, will be able to outrank us, which is not the case today because the governor today here does not get to do what the governor back in the day would. But this concept of having a fully functional with all powers to us is called full responsible government, right? Now, after this, there is nothing left. You've got to leave India. So therefore, what will happen is you will transfer powers to the Governor General and real powers to the Constituent Assembly to create a primary law called the Constitution. Very ironical that England themselves have a written constitution, a single written constitution, but they are more than happy to give powers to one singular body who will then make a written constitution for the very colony that they've colonized for more than 200 years, and they themselves don't have a single written constitution. So this becomes our independence checkpoint. And from here, when we become independent, we of course have the President, the Lok Sabha, the Rajya Sabha, and the Council of Ministers. And then till about 1956, we've got the President and the Lieutenant Governors, they call Raj Pramukhs and so on and so forth. And we basically have part A, B, C, D states. Part A states happen to be British provinces. Part B happens to be princely states. Part C happens to be some special areas like Delhi, etc. And Part D at that time only contained one state called Andaman. And then in 1956, we completely reformed this. We completely reorganize it. At the center, everything remains the same. From part A, B, C, D, we become states and union territories. We've got governors for states and lieutenant governors for union territories. And all states and some union territories will have a legislative assembly and council of ministers. And a few states will also have a second chamber. So this is basically our institutional evolution. But legal history is still about here. And this is just the legislative and the executive front for it. Till about 1858, you will see the word Governor General. And then post 1858, you will see the word Viceroy. You can use them interchangeably. They're effectively people at the helm, the in charge of colony of India, which is why post 1858 is also called the vice-regal age, right? But you can use either of the two, it's completely fine. They effectively mean the same thing. Now comes the important part. If you want to be legitimate, you'll have to be, even if you're a colony, you'll have to be more accountable. You'll have to give more representation to us. And when you do that, you'll also have to give us more powers. But the British, being British, this will never be that simple. It will never be as easy as it looks. There will always be more than what meets the eye, which is why when they're going to be more accountable, that means they will want us to keep a check on them. You'll generally see the Governor General or the Governor taking the final shot. They'll be the ones who will overrule most decisions. They're the ones who would not be bound by what our legislative councils or assemblies are trying to say. Bear in mind, legislative council is a term that we use sort of nationally, and legislative assemblies is what we use regionally. And when they want to give us more representation, there's always going to be terms and conditions to it. Who can contest, who can vote, how many times, how will their vote be counted, what is it that they can make laws on, what is it that we can decide for ourselves, what is it that we will actually have powers on. It's always going to be a big question mark. And when they say that they're going to give us more powers, it's going to be basically hollow. And let me give you 3 simple examples of how all of this is actually true. For example, through the course of all of this, you will hear of something called limited franchise. What India has today is called a universal adult franchise. Franchise effectively means the ability to vote. Now, what we have is a universal adult franchise. Adult means anybody who's more than 18 years of age. So, universal means anyone in India who's more than 18 years of age is entitled to vote. Of course, that is also subject to certain conditions. For example, prisoners cannot vote. But generally, under normal circumstances, everyone above the age of 18 in India is effectively entitled to vote. Now, that wasn't the case. If you didn't have property, you were not allowed to vote. If you were not educated, you were not allowed to vote. There were several restrictions on voting itself. In fact, when people were to be elected to certain councils or assemblies, you had to be of a certain stature. You had to have some amount of economic wealth. In fact, a lot of times people who didn't have land could not vote. Now, these technical details are not going to be asked, but the fact that we've had limited voting till we became independent, till the very end, still stands to be true. Even the Government of India Act of 1935, which was supposed to give us a very close feel of what it feels like to be self-sufficient, they had limited voting rights given to us. Secondly, you'll also hear of something called separate electorates and joint electorates. So electorates is nothing but a constituency in some form. Electorate is generally a larger term, but it could be understood in the context of a constituency also. So you represent a constituency and therefore you are a part of a legislature. Now the constituency has two components. One, the voters, and two, the person who's contesting. So what happens in a separate electorate is that, for instance, you say there's a separate electorate for Muslims. Now this would mean that only the Muslims are going to vote, and this also means that the contestant will necessarily be a Muslim. That's what is called a separate electorate. Now a joint electorate means that anybody can vote, but the person who's contesting has to have a specific criteria. For example, a joint electorate for women and depressed classes. We have the same even today. We have reservation for scheduled castes and scheduled tribes in our MP, MLA constituencies. With the new women reservation bill, we also now have joint electorates for women. So what does this mean? It means in a constituency reserved for scheduled castes, the person contesting has to necessarily be a scheduled caste. But anybody, whether they're a scheduled caste or not, can vote in that election. So that is what is called the joint electorate. The joint electorate system continues today. We have joint electorates for scheduled castes, scheduled tribes, now soon to be implemented, women as well. So there is a lot of terms and conditions that happen. Legislature and the executive tend to be your two primary organs of the state. But one must not forget that there's also something called the judiciary. Now, what generally happens here is when the company comes to govern its subjects, they would have their own company courts. The company courts are going to be for company subjects. Now, who is a company subject would also be a matter of concern, would be a matter of dispute, would be a matter of grave problem. Then what will happen is, over a period of time, you will see that proper crown courts are established, especially when the crown takes over after 1858. So we originally start with high courts, then we have Supreme Court and high courts at the same time. Then we cancel out Supreme Courts, we only have high courts. Then by 1935, we have the Federal Court of India and the high courts. And throughout all of this, we have what is called Privy Council. So the Privy Council, in one way, is the highest court in England for all of England's colonies. So let's say England has about 100 colonies. Ultimately, all cases on appeal would finally come to the Privy Council, if they were allowed to come to the Privy Council, if the cases had merit to be heard by the Privy Council. The Privy Council is basically a very, very high court, a very, very supreme court in England for the colonies of England. Now, there haven't been any questions from here, but the general principle remains the same as far as our prelims is concerned. All through this is effectively the evolution done through certain sets of laws. Now, let's start with each of these. Let's understand what they are. And we have to do them in the slightest amount of detail, because please remember, unlike preamble, rights, directive, principles, this is a low yield value topic. So the more crisp it is, the shorter it is, the more compact it is, the easier it is for you. So we start with 1600. Now, what is 1600 known for? 1600 is known for the entry of the East English India Company. Now, of course, the date was the 31st of December 1600, and Queen Elizabeth at that time had basically granted a charter to a company of London merchants to trade with East India. Now, a charter is nothing but a permanent which is to be given to a group. Now, this charter gives the company judicial powers, it gives the company executive powers. In fact, it also gives criminal powers, but it is only for company subjects. But the company subjects itself is a very, very abstract term. Are you a company subject if you're a British national? or are you a company subject who is in any way working for the company? And at that time, you would generally see there are empires in India, there are kingdoms in India, and these kingdoms and empires are going to have their own legal systems, their own justice system. So there is going to be a lot of local conflict at some given point of time. But basically, what happens is this is the start of the imperial legal culture. The company slowly expands, the company slowly starts even deciding on cases with respect to non-company subjects as well. And not only are local triggered, the kingdoms triggered, even back home, for them back home in Britain, the parliament is irked, the council of ministers are therefore going to be irked. So what effectively happens is that by about 1726, the British Parliament, and this is after the Glorious Revolution, is extremely disappointed and flustered about how much of abusive or how expensive and how exploitative the company has become. Now, by no means they meant well for India. What meant was that they were unhappy with how the company was enjoying far too much freedom without any checks and balances whatsoever. So the Charter Act of 1726 wanted to sort of curb the powers of the company. So back in the day, company court's decisions were finished and ended there. But now, on appeal, go to the Privy Council and so on and so forth. Company appointed governors were also then given very, very defined legislative powers, and the company was not able to digest this, and therefore the company eventually started again transgressing these powers. There were enough cases registered, but what you need to just know is that 1726 was effectively to control and regulate the powers of East India Company while giving them legislative, executive and judicial powers. And that's when the turning point happens in 1757, the Battle of Plassey, which is why a very famous textbook in India is called From Plassey to Partition. So what effectively happens is the company, which is led by none other than Robert Clive, had defeated Nawab Siraj-ud-Daulah of Bengal, and this was the first major disruption to how things were to status quo. So what happens is when you defeat Siraj-ud-Daulah, you effectively gain certain revenue rights, certain land rights, certain tangible ownership of a certain amount of territory, and therefore the Diwani rights of Bengal, Bihar and Orissa were granted to the company. While they were still the Nawab was basically nominal. The Nawab was basically just there for the dignity and the respect of it. But real powers were, of course, held by the East India Company. So the East India Company now becomes a very, very large landed power. Now, again, with great power comes great abuse. Unfortunately, in their case, it never came with great responsibility. So therefore, what ends up happening is the company starts abusing its powers. The company starts taking things for granted. The company starts transgressing their jurisdictional limits. And that is why they are effectively sort of faced with another regulating act called the Regulating Act of 1773. Now, several changes have been made to this act. They're not important for the prelims exam. I'll give you some reference to this. But the Regulating Act of 1773 wanted to further control and give more structural reforms to the organization and the affairs of the company. So, therefore, the kind of autonomy that the company was enjoying had to be reduced, and the British Parliament could have greater supervision over the affairs of the company. That was one of the primary effects, one of the primary outcomes of the Government of India Act of 1773. Now, the Governor General was having a blast all this while. So, they effectively sent 4 people to aid and advise the Governor General. The Governor General could still reject their advice through certain amendments that were made later on. 1784, etc., etc. But the 4 executive council members were supposed to be the restraining force on the very expansive powers held by the Governor General. By now, you had 3 major territories expanded under you. You had Calcutta, you had Bombay, and Madras. And when there are 3 equals, there's always going to be a question, who is more equal than the other? So what they did was they placed Calcutta at a higher pedestal, and Madras and Bombay became sort of number 2 to the Calcutta presidencies. And in a way, Calcutta becomes the national capital for Britain at a time when there was no nation whatsoever. But nonetheless, and to reaffirm what they really wanted to do, they set up what was called a Supreme Court back in the day in Calcutta in 1773. This was to be very closely modeled, and therefore you had kept a 5-year term for all of these guys, but it eventually was meaningless because the Governor General was still trying to override the advice of the Executive Council. Now, why was this case? It's because there were subsequent acts that were passed in 1781, in 1784, there were charters of 1813, charters of 1833. There was an amendment that was made to the 1773 Act in 1793, and all of this had very substantially diluted whatever you want to do with 1773. So the acts of 1781 and 84, the charters of 1813 and 1833, they're not important for the prelims exam. This is just to give you some form of context. And the amendment that was made to 1773 in 1993. Now, the idea was that because there was so much parliamentary discontentment in England, they really wanted to secure parliamentary control. And the parliament wanted to have greater say in what everybody was doing. Therefore, in 1781, they exempted the Governor General from the Supreme Court. In an amendment that was made in 1793, the Governor General could override the advice of the Executive Council on such extraordinary cases. And because Calcutta was seemingly superior, a Supreme Court was set up in Bombay in 1823. And there was a lot of tussle between if there's a Supreme Court in Calcutta and there's a Supreme Court in Bombay, who's the bigger one, or are we all equal? So there were a lot of organizational challenges. And then finally, in 1858, the Queen of England at that time, Queen Victoria, had issued a proclamation, and she became what was called the Empress of India. And therefore, what this basically means is that Indian territories which were under company rule now become directly under the Queen's rule. Now, this also means the Queen is the monarch, so they become under the direct control of Council of Ministers of England and the British Parliament. And this is actually where our story starts, because this is actually where our life tends to be greatly affected because of now institutional changes that are going to be made. So we first start with what is called the Indian Councils Act of 1861. Now, we've already done the broad structure before. So what does the Indian Councils Act of 1861 do? It effectively restructures the Governor General and the Governor General's Executive Council. Now, this is happening pan-India or pan-British India, by making sure that you are now going to create a sort of separation of powers between the Executive Council and the Legislative Council. Now, this effectively means there is a legislature. Now, this legislature is going to have British and Indians to it. But of course, the Indians would have a negligible role to play. The British would effectively have a larger role to play. But this was a functional division. This was not only for separation of powers, but this was also to create some form of limits to the office of the Governor General and also the Executive Council. But at the same time, you didn't want the legislature to also get carried away, because forget not, you are still a colony. which means you would require the assent of the Governor General on practically any matter, no matter what. And all laws would require a compulsory sanction of it. In some cases, you would also require something called prior sanction. And both of these concepts are still absolutely existent today. Now, because Bombay and Madras were fighting for their legitimacy, Bombay and Madras also get independent legislative powers. So, the governors of Bombay and Madras would effectively also have some territorial jurisdiction to make some kind of laws. And because the Supreme Court thing had created a lot of confusion, they abolished all the Supreme Courts, and you had a Supreme Court of Bombay, a High Court of Bombay, a High Court of Madras, and a High Court of Calcutta. Now, it is also actually for the first time where emergency powers are actually given to the governor of what were called British administered provinces or British administered territories. So this is their first substantive act on an institutional change that has happened to us. Now, immediately after this, you will see that in 1909, we passed what is called the Indian Councils Act. Now, the Indian Councils Act of 1909 is also called the Parliamentary reforms because of the reforms, the suggestions that were made by Morley and Minto. Now, there are of course four very, very important things. Now, the reason is that it is in this context that there is obviously a little bit of resentment, and they wanted to counter it by providing for the first time some form of elections. Now, here when members were to be appointed to the Legislative Council, there were no elections. Now you would have elections. Elections where? To both central and state legislative councils. You started creating legislative councils at the level of the state. If you see this carefully, here you will have legislative councils here, and you will also have legislative councils here. So these are your state legislative councils. You will have elections here, you will have elections here. Basically giving some form of representation, some form of democratic mandate in a certain kind. So this becomes very, very important. This becomes an extremely hallmark of a step. Now, this was good. Of course, the elections were fairly limited. There were too many terms and conditions. But yes, you would have elections to central and state legislative councils. There were excessive limitations on how you could vote. There were excessive limitations on who could contest. But at the same time, you were creating a multi-layered British ecosystem. And that's the point. You have a Governor General for India. You have presidencies and provinces. Presidencies tend to have more British power. Provinces tend to have less British power. Both are British governed. And of course, you have princely states which are complete the picture. The idea is you have now started to give executive council to your provinces as well. Otherwise, you just had the governor, and the governor was enjoying as the single person in charge of taking care of everything. So you're now creating multiple layers. This is exactly what we had discussed before. So you have a governor, and then after some time, the governor also has an executive. So you're simply evolving your ecosystem. Now, this is also the sign of something terrible that's going to happen, and this is going to cause a major rift in the way the leaderships were working at that time. Separate electorates for Muslims at the level of the states, not at the center, which means when we talk about the Legislative Council with the Governor General, there is no separate electorates. It's only and only for the states. Now, the separate electorates, as I've explained to you, this means the voters are only going to be Muslims, and the person who's going to contest is only going to be a Muslim. This electorate is nothing but indicative of what is called the divide and rule policy that the British have been rather infamous for. Apart from this, as I've also told you, there is going to be an issue where you start creating a new office, both at the center and the states, called the Office of the Vice President. So these become your primary objectives or features of the Government of India Act of 1909 or the Indian Councils Act of 1909. The reason it's called the Indian Councils Act is because you are seeing more changes to the councils. You're seeing elections happening to the central and the state councils. You are also seeing separate electorates for Muslims, which is again happening at councils. You're giving limited voting and limited contesting rights, which is again happening at councils. So therefore, a large part of what this act is trying to do is reform your legislative chambers. And it's not a very well-intended reform, but a reform nonetheless. Now, then we have what is called the Government of India Act of 1990. Now, if there's one thing you should Government of India Act of 1919 for, is the diarchy that was again to be given at the level of the provinces or the states, because at a national level you would not want to lose any form of control. So whatever representation you would want to give, or more powers you would want to give, you would want to give them at a provincial level. So what is basically a diarchy? A diarchy is, there's nothing happening at the central level. You've got the Governor General, you've got the Executive Council, you've got the Legislative Council. Now you have elections to the Legislative Council also, but at the level of provinces, you've got the Executive Council. You used to have a state legislative council. Now you have a provincial legislative assembly, and from here you're going to have proper ministers. So you have effectively created some form of a mini parliamentary system, but at the level of the states, because it's closer to people, it's more intimate, and therefore these ministers are going to be collectively responsible to the respective assemblies. Now, we anyways have X things on which the center can make laws on, Y things that on which the state can make laws on, Z things on which both the center and the states can make laws on. The problem is with Y. Now there are two state power making bodies within the state. So what is going to happen is, you're going to keep a separate list of things on which they are going to have powers, and they are the ones giving us power. So they've reserved some things for themselves, and they would give some powers to us, law and executive making power. But as we know, all of this would effectively be hollow, and the more crucial, the more difficult, the more sensitive power would again be left with the reserved list, which is effectively with the governor and the executive general. If I also remember correctly, the Government of India Act of 1919 was also fairly snottish in their own way, in the sense that they said that this will not be applicable to civilizationally backward areas, which the British thought was civilizationally backward. So almost Assam, Orissa, the entire Chota Nagpur Plateau region, they were all to be exempted from even having a shot at very, very limited and very, very conditional democracy. However, this was something that was promised to us. This was something that was to be delivered to us, and Congress had of course rejected the act, said it was indiscriminately, and they would still fight the election nonetheless. There was a review that was to happen of this act after 10 years in 1929, which modern history would remember with something. So basically what is happening now is that at the level of the states, we've got two power centers. One is the British center and one is the Indian center. The Indian center, of course, is extremely limited, extremely concise, and extremely, you could say, insufficient, for the lack of a better word. And then finally, what you have is the Government of India Act of 1935, the last piece of legislation. Now, what is very interesting about it is that it wanted to do something, but only half of it was effectively done. Now, the Government of India Act wanted to create what is called an All India Federation. So, it for the first time wanted to give us the idea of India by merging princely states into British provinces, which is why on several occasions, for example, when you read territorial provisions and more importantly, when you read citizenship provisions in the constitution, you will find a reference to India defined as per the Government of India Act of 1935. This is what is called undivided India as we would know it to be. Now, what they wanted to create was an all India federation, which effectively meant that you would have provinces and princely states become a part of a larger political unit. Now, how would you do this? What you had done for states in 1919, you want to do for the center in 1935. So you wanted to create two centers of power for the center. So they wanted to create, there was of course the Governor General, there would be the Executive Council. This is one power center, and this would become basically Government of India Act 1919, but for the center, but at a national level. So instead of one legislature, they would want to have two, largely because you're representing such a large geographical area, and you would have ministers chosen from here who would be collectively responsible. Now, they said that there should be two houses, Council of States and Federal Assembly. Now, the members would come from provinces and the princely states. The provinces would have direct elections to this Council of States, and the princely states, because they're effectively kingdoms, they are monarchies, they would nominate people and send them across. As far as the Federal Assembly is concerned, and federal means anything which has two layers, so they would have indirect elections in the provinces. So we would have the already elected members of the provincial assemblies, their people to be sent to what is called the Federal Assembly, and then the princely states would effectively just be sending nominated members here. Now, all of this does not happen. It is all an idea. It is rejected because the states did not agree. Now, the princely states did not agree because this was effectively accession to India. It was effectively becoming a part of India, but it would come at a cost. There are rarely free lunches in life. So this effectively means that they would have to surrender their territory, and with that would come a surrendering of a lot of autonomy for a certain fraction of seats, and they were not okay with it. For them to get a certain fraction of seats, they would have to surrender almost half their territory to British, and they were not okay with this largely. The technical details are not important. As a result, it didn't fall through. So therefore, the previously existing ecosystem of 1919 for the center, this continued. So this was what was the case. So effectively, after 1935, what was previously happening since 1919 for the center continued, and this diarchy never happened. So basically, you had exactly what was happening up until now. You had a Governor General, Executive Council and Legislative Council, and what you did remarkably was have full responsible government at the provinces level, which means your Executive Council was gone. You had provincial legislative assemblies, and ministers would be chosen from them, and they would effectively be responsible to them. So you had basically democracy, except for the fact that the governor was an outsider. The governor was British appointed. The governor, of course, at that time would have far more powers than what the governors do have today, but nonetheless, this was the closest we came to parliamentary democracy during the British Raj. Now, if there is a center and the states, there has to be a power sharing mechanism. Like how we have the 7th schedule today, the union list, the state list, and the concurrent list. What we had was a federal list and a provincial list. Now, Obviously, if all powers are with one, so there is no allocation of sorry, no allocation of powers. So therefore, you would have one set of powers completely given to provincial legislatures. But at the federal level, what you would now have is a reserved list and a transferred list. This is exactly what was happening. So you would have a few things on which they would have complete powers, and on a few things they would have complete powers. So this was originally proposed. Now the idea is, because the All India Federation did not go through, and listen to this carefully, because the All India Federation did not go through, this also did not go through, because ultimately the Legislative Council was in great favor of the British. There was no diarchy anymore. So this was proposed. This also didn't happen because this didn't happen. And of course, if there are two lists and there are things that are mentioned in either of the lists, you've allocated them. But what if there is something that is not mentioned in either? And this was a prelims question. So residuary power would effectively be with the Governor General. You will not give it here because it would effectively be ineffective because you're a colony. You would want to keep it centralized. And this is the closest you can be to keep it centralized. So this was a PYQ question, which is nothing but residuary powers were with the Governor General. So this is the Government of India Act 1935. Now, apart from this, you expanded electorates which were separate in nature. Not only were Muslims, but also now several other religions also getting separate electorates. You had extended separate electorates to a very large number simply because they wanted to advance what was called their divide and rule policy. So therefore what they ended up doing was they gave more separate electorates to Christians, they gave separate electorates to Sikhs, and so on and so forth. And joint electorates not only for depressed classes but also for women. The Federal Court of India, which is today now the Supreme Court, was established in 1935. The Reserve Bank of India was also established because the Government of India Act had provision for it. So the RBI Act was passed later. And of course, emergency powers were more strengthened. So the Government of India Act 1935 has had a fair amount of role to play. But in the prelims, you'll generally see a question from here. These things are not generally asked. And when you come to subject-specific topics, I'll give a reference there and then. For example, the Government of India Act also contains something called Instruments of Accession, which is also a reference point for directive principles. So this is the last act passed by the British to strengthen or to establish their order. And then finally, the Indian Independence Act of 1947 gets passed. Clement Attlee is the Prime Minister of Britain at this time. And the Cabinet Mission just a year before had already provisioned for the Constituent Assembly. So what the Indian Independence Act does is, it transfers power to the Constituent Assembly from the British Crown. So therefore, the Constituent Assembly becomes the legitimate mandate holder for India. And the Constituent Assembly had a primary job to draft the constitution for us. So therefore, when the Indian Independence Act is passed, we are still an independent dominion, because the head of state is still formally the queen or the monarch. But after the constitution comes into force in 1950, that's when we become a sovereign republic. In fact, as a symbolic act, the very last article of our constitution actually repeals the Indian Independence Act, essentially trying to convey a message that the British are no one to give us independence, as they were no one to govern us in the first place, rightfully so. Now, as far as the prelims is concerned, you've got to know two things about the Constituent Assembly. One is the composition and the other is the structure. Now, there is no need to do the mathematical composition of the Constituent Assembly. What you effectively need to know is that we are going to be creating India, and India as per Government of India Act, which is effectively British provinces and princely states. And the Constituent Assembly is going to be evolving in its structure. You're going to have a pre-partition Constituent Assembly, and you're going to have a post-partition Constituent Assembly. So, of course, the post-partition Constituent Assembly will have lesser seats. So, the Constituent Assembly is supposed to have provinces and princely states, representations from British provinces and princely states. Now, the British provinces are to be, the members of the British provinces to the Constituent Assembly are to be indirectly elected by members of the provincial legislative assemblies, which means existing MLAs will elect members to the Constituent Assembly, very much like how the Rajya Sabha gets elected. The only difference is each Constituent Assembly will have three parts: Muslims, Sikhs, and whatever is left, general. So, all Muslim members of a specific legislative assembly will choose Muslims, all Sikh members will choose Sikh, and everybody else will choose general. And there is going to be a number defined in proportion to their population. Now, this being the nature of it may not be asked, but this much is important, has been asked very recently. And members representing princely states will not be on an election basis, but on a selection basis, and this has to be done on consultation with the kings or the queens of the princely states. And this is honestly more than enough as far as composition is concerned. Now, when we look at the structure, so the structure is again fairly simple. What we are looking at is, this is nothing but a sort of a parliament, but a very special parliament whose job is to create what is called the Constitution of India. Now, at the very helm of affairs, you have B.N. Rao, who's an advisor to the Constituent Assembly. That's number one. Number two, the role played by B.N. Rao is extremely important in terms of him introducing ideas and advising everybody else working in a certain manner. So if the parliament today has parliamentary committees, they would have a certain set of committees. The most important of it, because your primary job is to draft the constitution, is the drafting committee. The drafting committee is headed by B.R. Ambedkar. In UPSC, they generally don't ask member names. In state services, of course, they do. But the chairperson of the drafting committee is nobody else than Dr. Bhim Rao Ambedkar, who's obviously done a splendid job in the way things are running and in the way the constitution has been drafted. Now, the drafting committee is supported by four extremely important committees. These are the four ones which are important. You have a committee on fundamental rights, minorities, tribals, and excluded areas. And their job is to give suggestions or ideas on provisions regarding rights, minorities, tribals, and excluded areas to be included in the constitution. So you will have a lot of to and fro, back and forth between the drafting committee and this committee. Similarly, you'll have a committee on provinces. You'll have a committee on chief commissioners, provinces or chief commissioner areas, which are effectively union territories, and a committee on rules and procedure. Each of these committees are headed by four extremely important people. The Rights, Minorities, Tribal Areas Committee is headed by Shri Iyer. You will have the Provinces Committee headed by Vallabhbhai Patel. You will have the Chief Commissioners Committee headed by Patabi Sitramaiya, who will play a very important role in the second second Provincial Linguistics Committee set up for state reorganization. And third is Dr. Rajendra Prasad, who heads the Rules and Procedures Committee. Now, in certain cases, so for example, if the chair is Sri Allada Swami Iyer, you will have separate people heading fundamental rights, minorities, and tribals. So, for example, the person heading a subcommittee on fundamental rights under the larger committee, J.B. Kriplani. Apart from Kriplani Sahab heading fundamental rights subcommittee, you will also see, for example, H.C. Mukherjee, who would be heading the committee on minorities, and so on and so forth. So the idea is that this is the organizational framework. The analysis of the Constituent Assembly is never asked. So please don't get into whether it was truly representative or not. Was it good enough or not? Of course, most members of the Constituent Assembly were from the Indian National Congress. That's because after 1937 gave full democratic setups at the regional level. Provincial elections were held in 1937, and therefore the Congress had effectively won almost a majority of seats in almost all places. So yes, most members would come from there. Similarly, you would also see that there were enough. There were women members, not enough. There were also Dalit members. Also, there were also members from other religions. But this is the larger idea. The first Lok Sabha elections happened in 1952, which means from 1946 till about 1950, you are the Constituent Assembly. From 1950 to 1952, you are a very limited Constituent Assembly / interim parliament. And then, of course, from 1952 onwards, you have the first Lok Sabha and the first set of elections in the country. But this is effectively what is India's legal history. Let's not go in any more detail than this. If there has to be a question in the prelims exam, it would sufficiently be handled from here itself. So that is that. And on that note, I'll end this lecture and I'll see you for territory and citizenship in lecture number 4 on Monday, which is effectively tomorrow. Thank you for watching. Bye-bye.